All right, I'd like to thank you for joining us for this webinar, Understanding the Information Blocking Rule, Compliance and Exceptions. My name is Carissa Miller. I'm the Program and Communications Specialist for Montgomery County Medical Society. I do have a few housekeeping items before we begin. This call is being recorded and we will post it online for our practices to access this week. So please be aware that the recording is ongoing. We have muted participants at the beginning of this call for sound quality purposes. But we do welcome your questions during the Q&A. So feel free to submit them throughout the session via the chat function. And then if you are on the phone, feel free to unmute yourself during the Q&A to ask a question by pressing *6. Today's program will provide a brief summary of the HHS Office of the National Coordinator for Health Information Technology, or ONC for short, their final rule on information blocking under the 21st Century Cures Act, which will go into effect on April 5th, 2021. We will discuss what information blocking is, exceptions to the rule, and outline a roadmap for your practice to come into compliance. We're very fortunate today to be joined by Dr. Reza Ghafourian, MD, JD. He is a healthcare attorney and the founder of G2Z Law Group, PLLC, a long participant of MCMS's Physician Connect partnership. With over 10 years of experience, he counsels clients on health law and healthcare regulations, including fraud and abuse, such as anti-kickback statutes and Stark law, privacy and security, reimbursement, CMS appeals, and telemedicine. Thank you, Dr. Ghafourian, for being here today.
Thank you for inviting me. Thank you for the nice introduction. Should I just go ahead? Are we starting?
Please do.
Okay, so thank you everyone. Thank you Montgomery County Medical Society for the invitation. We're going to today discuss the recent information blocking rule, well, not recent, from last year, that it is now, the compliance of which is now due by April 5th. We're going to talk about the compliance, the different aspects of the rule, and the exceptions that would apply that you can use in terms of for getting out of any issues that come up with the blocking of information. A little disclaimer at the beginning, what we discussed today is basically pretty much opinion and it's not legal advice, and this presentation would not create or establish an attorney-client relationship. So a little bit on the history of how information health technology has been developed. Over the past decade, we've had starting from 2009 with the HITECH Act, we've tried to move medical information or health records from paper records to technology and electronic format. And the HITECH Act kind of tried to push that by spending billions of dollars, but all it could accomplish was to get paper information from silos to silos of electronic information. The health information currently is still not interoperable, and the flow of information still blocked by silos of information with different healthcare incompatible medical health or health record systems. So what the Information Blocking Act or rule and interoperability rules really tried to accomplish was to create or take away those walls that prevent the free flow exchange and use and access of health information, and to make sure that everybody can access this health information freely and without impediment. And to do that, the Office of the National Coordinator for Health Information Technology, the ONC office, has published the Information Blocking Rule, which came out back in May, went into effect on the 30th of June of last year. And the compliance deadline of it was supposed to be November 2nd, but then it was moved to April 5th of this year. And with this information blocking rule, ONC really defined what it is that is considered blocking information to go from one point to another, to be accessed, to be exchanged, or to be used by different healthcare entities and patients. So we're going to talk about pretty much what the definition of it is, what is information blocking, and it is basically any practice by an actor that interferes with access, exchange, or use of electronic health information unless or except an exception applies or is required by the law. And based on that definition, the requisite legal elements of an information blocking claim would be that there has to be an actor that blocks the information. There has to be electronic health information as defined by the rule involved in this blocking or blockage. The practice is likely to interfere with access and exchange or use of this electronic health information. The actor had the requisite intent to block the flow of the information. Practice is not required by law and doesn't fit any of the exceptions. So all of these have to be present for a claim of information blocking to be successful. Let's talk about the terminology of the definition we just read. We'll go through a couple of slides defining each term as it applies to the rule. So engages in the practice. It includes an act or an omission of an act. So even if you don't do something, or when you could do something and you don't do it, and it ends up having an adverse effect on flow of information, that would be considered still a practice. Likely to interfere it basically means there is a reasonable and a reasonably foreseeable risk that access to the information can be prohibited, prevented, or materially discouraged. Even if there is no harm, this can still be considered an interference. Access is when is an ability to get to the EHI for exchanging and using it. An exchange happens when transmission happens between several parties on different technologies, systems, between softwares and platforms. And a use is when, after it's exchanged and accessed, you're able to review it, read it, and understand it, and act upon it. Electronic health record is also defined by the rule. In this definition, the rule ONC relied back on definitions of electronic protected health information from HIPAA regulations. And they said that the electronic health information are electronic PHI that's in a designated record set. And a designated record set from HIPAA definition includes medical and billing information records of the patient and any other records that healthcare provider relies on to make decisions about the patient. Again, based on the HIPAA definition of designated record set, these electronic health records and electronic PHIs do not include psychotherapy notes, de-identified data, or any information that was compiled in a reasonable anticipation of legal proceedings. Actors also are defined within three separate categories. Healthcare providers, which include hospitals, skilled nursing facilities, home health agencies, long-term care facilities, blood centers, ambulatory care centers, physicians. Those are all healthcare providers. Then you have health information networks and health information exchangers who are involved in creating a platform or an exchange platform where they sort of allow the exchange between two separate parties. And you have health IT developers, who are people who are going to generate platforms or software that capture information, and they can access it from different points. The requisite intent for each of these parties has been defined a little bit differently by the rule. So there's a lower level of or threshold for proving intent if you're a health IT developer or an exchange or network. And that means that in developing your platform or your software, you should know, you knew or should have known that a practice that you're implementing would interfere, prevent, or materially discourage the access, exchange, or use of an EHI. For a healthcare provider, the threshold is a little bit higher. The rule requires that the healthcare provider must know, or must know, not that should have known, but must know that such a practice is unreasonable and likely to interfere with the flow of information. So the threshold is different. OIG bears the burden of proving that a healthcare provider knew something or knew that his practice was unreasonable and likely to interfere with flow of information. But if a healthcare provider wants to I apologize. And this is, a healthcare provider wants to use an exception as a defense, the burden of proof is on the healthcare provider for showing that an exception applies. So this rule, what does this rule mean for clinicians and hospitals? It means that it makes it easier for patient data to be requested and be accessible, and it would be inexpensive to do so. It allows choices of applications for clinics and hospitals to be implemented. Implementation would be easier, and it would allow for a better patient safety. What does it mean for patients? Similarly, it means that patients can access their information more readily, more cohesively, and also be able to use that information to shop for better care and reduce the management of costs. So let's talk about some examples that the rule showed that would be considered information blocking. So one example is when internal policies are more restrictive than applicable laws. So let's say the law does not require that you get patients' consent or authorization if you're disclosing the information for treatment to another physician. And your policies require that individual provide written consent for this type of treatment. That would be information blocking, because now you're creating additional hurdles for this information to be easily and readily transmitted to the other provider for treatment. Misunderstanding the law is another reason. If the HIPAA rules do not require you to do something, and then and you misunderstood it and say that is some hurdle is required before transmission of information, then that would be also blocking. Hospitals or healthcare providers can direct their EHR the developers to configure more difficult EHR flows, and that would also be considered if it's not standardized, the technology, and it makes it more difficult for users to access it, that would also be considered a blocking of information. Unnecessary delays is another example. Let's say you have the capability to provide information to to a user on a same day access or a real time access, but then your policies would require that you do not do that for 2 days before patients can have access for it, or for a week before patient can get access to it. Requiring to adopt non-interoperable EHR is another problem. So now you have to make sure that your platform, the electronic health record platform, is compliant, interoperable, and it works with different systems as required by the rule. And if you intentionally adopt something that doesn't work with other systems, then you're blocking the flow of information. And then discrimination against EHI vendors is yet another example where you set fees and licensing requirements for one set of vendors, and then you don't apply the same thing to others, and that would also cause problems and be considered blocking of information. Now, the rule defined what is really not considered information blocking, and those are fall under basically 3 categories. All the rules, federal rules, state rules, and regulations, they still apply. All the court orders and tribal laws and the settlements that have been established still apply. And this rule, this information blocking rule, does not trump any of that. In addition, the information blocking rule implements 8 exceptions that you can use in addition to what is required by the law. And then also, if the actor doesn't have the required level of intent, that would be another way that the actor would get away from inadvertently, not knowingly, for example, for healthcare providers can get away from information blocking. Now, we want to talk about the 8 exceptions. These exceptions are pretty involved, they're complicated. We're going to discuss some aspects of them, going down from starting from exceptions that involve not fulfilling a request to access, and then we get into exceptions that involve some procedures for fulfilling requests to access, licensing and fees and content. Okay. I'm not going to read the entire the slides. I included a lot of information on these slides that you can have access to and read at your own time. I'm going to pretty much sort of summarize most of them for you on this presentation. So preventing harm is one exception that really applies to the practice of healthcare providers. You would like to have the option, and the ONC recognized that healthcare providers require the option that if they within their the purview see that it's reasonable to withhold certain information because it would harm or cause a significant risk or significant harm to a patient, they should be able to hold that information and not disclose it. But there are certain conditions that have to be met for you to be able to enjoy or use this exception. Let's say there is a patient has domestic abuse information on its medical records, and the notes have some of the notes include some domestic abuse information. And let's say there is an authorized request from the abuser with a consent form from the abused to receive that the entire medical information of your patient. If you hold a reasonable belief that the practice that holding the portion of the notes that include the domestic abuse records would reduce or substantially reduce the risk of harm to the person, then you can use this preventing harm exception. And this preventing harm exception has to be for harm that has that is caused to a natural person and not to any company or an organization. So it has to be to a person. And in addition, another requirement of it is that the physician or the healthcare provider who's withholding the information must have a direct relationship with the patient. So it couldn't be a physician or a healthcare provider who does not have a relationship but has the records of the patient, and they never had a physician-patient relationship established. Another condition is that the practice of blocking has to be no broader than necessary, meaning that if you can withhold the domestic abuse records and release the rest of the records, you should do that and just hold that record. And then the requisite condition also requires that you have to be, the harm that you believe is going to occur has to be a significant risk of harm or a significant type of harm or physical harm that can be imparted on the patient. Now, in this situation, a patient can appeal the denial, and you have to have policies and procedures in place to allow such an appeal for if you're using the preventing harm exception. And you also have to finally well document the facts of the prevention. Now you can do this in several ways. You can either have or address these situations on a case-by-case basis, which is very difficult for looking at every request for electronic health records that you want to consider on a case-by-case, or you can upgrade or update or amend your policies to have at least certain criteria for certain types of records that go out that you would want to have blocked, basically, for, let's say, domestic abuse. If you have certain types of labs that you don't want to go out, if you have adolescent patients that have STD labs that they go through, and your medical records doesn't segment them out. So you got to implement some policies that considers your type of practice and the type of harm that would come from your type of practice to be able to restrict these disclosures. The next one is a privacy exception. Under a privacy exception has four key conditions or sub exceptions that we're going to talk about. The most important one is number one, which talks about a precondition that is not satisfied. And this is important because, for example, there are certain times that you have commingled records that part of it requires patient consent and authorization, part of it doesn't. And and the request that comes through doesn't have the requisite or it doesn't satisfy the precondition. Let's talk about, for example, Part 2 programs where it's for substance abuse restrictions that even an authorized person who wants to access these records must have patient consent before they can get those records. Now, an authorized person could, let's say, if it's a large data set, you have Part 2 program records, and you also have behavioral health progress notes. You can disclose the progress notes, but you should always, you want to keep the Part 2 program or block the dissemination of the Part 2 until you get the requisite consent. So that's pretty much what it means to have precondition not satisfied. Now, there are certain conditions to this preconditions not satisfied. It means that you have to tailor your response whenever it's possible. For example, when you have two sets of records and you can separate the Part 2 from the other part that could be disclosed, you should do that. You have to also apply the manner in which you do this consistently and non-discriminatory, so everybody should get the same treatment when they make these applications for or requests for electronic health information. You should have either written policies that explains your the manner in which you're going to apply this rule, or you have to document your prohibition or prevention of dissemination of records on a case-by-case basis, which is very difficult, of course. And then you have to also take reasonable efforts to provide reasonable assistance to fix any issues. So if there is a patient consent requirement, then you have to take the positive steps to get to inform them that you need the patient consent and see if you can obtain it before you disclose the information. So these are some of these conditions are pretty involved. It's important that you really go back and look at your policies and make sure that you implement certain procedures and policies, augment your current compliance policies to capture documentation and sort of the way that you're going to handle these exceptions, because dealing with them on a case-by-case basis obviously wouldn't work, because you also have to attend to your practice. The other three conditions, for example, are not as important as number one, but we can quickly discuss them. The health IT developer, if they're not a HIPAA covered entity, you may use and they're not compliant with the HIPAA privacy rule, you may elect not to provide the information to them. There's also a denial of an individual request for EHI that's consistent with certain parts of the HIPAA. These are these 45 CFR 164 rules. These happen to be or apply to the right of access, and these are basically information compiled in reasonable anticipation of a civil criminal record and psychotherapy notes. This is what these 1 and 2 are applied to, and we discussed those. And then with respecting an individual's request not to share information is when an individual who has the right to request from you not to disclose their information under certain circumstances. So those are privacy exceptions. Security exceptions, surprisingly, we do not have a lot of examples under in the rule for this exception. I think it's because mostly it's a kind of a common sense exception. So this is, you want to use this exception when dissemination of information or disclosure of information would threaten the safety and confidentiality of your electronic health records. For example, let's say a person calls you and says and requests or sends an email to you requesting to provide her medical records. Even though there's no law that applies here, you should take the steps to verify the identity of that person to safeguard the confidentiality and the integrity of the EHI. And then you got to make sure that you apply again this rule for safeguarding and the confidentiality of EHI to everyone. And just because you receive an email from someone that it's your buddy and you know it, you don't apply the law, and then you don't apply the exception, and then you apply the exception to another person. So it has to be consistently applied and non-discriminatorily applied to everyone. So it has to be part of your policies and procedures. So that's basically the extent of this this security exception. Infeasibility exception is a broad exception, and it's one that could be used probably most of the time for if other exceptions cannot be applied by healthcare providers. So there are there's several key conditions. One has to be that has to be met. For example, under infeasibility, it basically means that it is impossible for you to provide those documents. And one could be under uncontrollable events. In that case, where there is a public health emergency like COVID, there's a disaster, there's a riot, there is a strike and civil insurrection, and we've had all of them over the past year. There's a possibility that you can use this exception and not provide that information, but obviously you have to document it and make sure that you show that you were unable to provide that information. Segmentation is another condition that you can meet. Let's say you have Part B record, Part two records for substance abuse intermingled with regular records, and your system doesn't segment it out, and it's impossible for you to segment it out. At that point, because unless you receive proper authorizations, you can keep those records and not disseminate the entirety of the records. And if it comes out that there are certain circumstances that you just cannot, under those circumstances, provide those records, let's say a healthcare organization sends you or requests tons of information from you, from all of your patients, and it's really financially infeasible for you to provide that information to them because you're not in the business of providing electronic health records, then you can use the third bullet, which is infeasibility under the circumstances. You have to copiously document it contemporaneously at the time that it happens, and making sure that you really make a case that you cannot provide the information. All of these, for the infeasibility exception, you have a deadline of 10 days to apply, to make a response or your response of denial for providing the information. The health IT performance is was basically implemented because ONC recognized that when you're dealing with technology, there are times that the technology would be down. You have to update it. You have to update the software. You may want to change vendors. So there's a time that you will not have access, or your access is restricted or diminished because of technological issues. And during those times, you're allowed to not provide, or use this exception to not readily provide the access, exchange, and use of the information, as long as the period is no longer than necessary, it's not discriminatory, and it's consistent with the existing level of agreements that you have. There are three other procedural exceptions that apply, and they really don't apply much. The first two, the licensing and the fee exceptions, don't apply to the practice of healthcare providers much, but we can quickly cover them. Licensing is when, let's say, a healthcare IT developer has a technology and they want to license it, and this exception allows them to take their time and get into license negotiations. 10 days they have to from the receipt of information to request for a license, and then 30 days to reach a license. And if it's infeasible, then they can rely on some other exception. For the fee, also, ONC recognized that if you have an innovation and a technology that you want to license, you should be able to charge a fee for it and be profitable, reasonably profit from that fee, and that is the fee exception. Finally, the last exception is a content and manner exception. This exception requires you to disclose the information the way that it was, for the content that it was requested and for the manner that it was requested, unless you're unable to. And this exception kind of leads back to the other the fee and licensing and infeasibility conditions if it doesn't work out here. In terms of content, we know that the rule doesn't require at this time until May of 2022, there's a specific set of uh, data that you can provide. After that date, you have to provide anything that has to do all the electronic protected health information within a designated data set. But before that, the data that you must be providing is listed in the US core data for interoperability standard, and they list exactly the kind of categories of data that you must provide at this time, and they're giving you another year to include everything else in that. So that's the content condition, and the manner condition is that it could be they're asking you for a specific technical production of documents, and if you're not able to provide that, then you can provide it in another manner, but you again have to document it and show that you don't have the technology to fulfill that request just the way that they're asking you for it. You use an alternative manner, or if you cannot reach an agreeable terms with the requester, then you can rely on some other exception like an infeasibility. So if you don't have the technical capability of producing the documents in a specific way, then you can say it's I cannot do it technically, I can do it in another way. If the requester says no, I want it specifically that way, then you have to rely on another exception, which is, you can say it's infeasible for me because I just don't have the technology to do it. Okay, so enforcement, again, as we discussed, OIG enforces the information blocking rule. The penalties, just like the intent, as we discussed, are kind of divided into two portions. The higher penalties are reserved for health IT developers and health technology networks and exchangers, $1 million per violation. OIG, with respect to healthcare providers, will basically, either put the healthcare provider on some sort of a program, or they will refer them to an appropriate agency like a CMS or OCR to deal with the information blocking issue. For example, OCR already investigates HIPAA violations. So if this involves HIPAA violation, they will refer you to OCR. And if it's start violation or some sort of a claim violation, they will probably send you to CMS. So finally, how do you get your practice ready for this information blocking rule that came out? So I would suggest starting with your compliance and your compliance program. Review your compliance program. Make sure that first you comply with the written policies and procedures for HIPAA. Those are required standards. That you have your risk assessments in place, and then again review the policies to make sure that if there are any policies that are implemented that are not required by law and it would lead to information blocking, you want to retract those and take those out. You want to implement additional policies and procedures to sort of enjoy or kind of bring into your policies the different requirements and the conditions of the exceptions for your practice. If you're dealing with adolescent patients, then you want to implement policies as to how you want to deal with the adolescents, the disclosure of their information to their parents, for example, and access of parents and guardians to their information, what kind of information would cause significant harm, the significant risk. So you really want to look at each one of these exceptions and sort of try to cater your disclosing use and disclosure HIPAA policies to either include some of these exception criteria and conditions, or create additional policies that would address these, because it's much easier to rely on your staff who are going to be trained on these policies to implement the exceptions and documentation, rather than you individually on a case-by-case basis looking at each one of the electronic record requests. Again, you want to train your workforce. You want to make sure that you look at your electronic health record system, making sure that they're coming up to date, that they're making sure they're following interoperability requirements, that your uses or all of your data is accessible whenever needed. If you need segmentation, and that's something that's important, that you want to segment, let's say Part B, Part 2 records from regular records, then see if your electronic health record would allow you to do that. It is important or helpful to implement some sort of a process for identifying and reporting blocking complaints. If something comes in, you want to make sure that you immediately respond to it. Monitor, investigate, and enforce compliance by doing regular risk assessment. Already HIPAA requires you to do annual risk assessment for HIPAA, so you can implement this into your policies. So that's pretty much it. There's some resources that you can access. The AMA has two really good resources that they wrote up. It's very helpful for healthcare professionals. And I would suggest that if you have questions, take a look at those. And you can always call us or reach out to me. We'll be happy to assist you in this.
Thank you, Dr. Ghafforian. So we have had a few questions come into the chat, and I will just encourage our attendees that if you have a question to go ahead and submit it there. We're going to start at the top. So our first question from Dr. Marissa Leslie came in as you were explaining the definition of information blocking, and she asked if you could elaborate on the definition of psychotherapy notes.
So the definition of psychotherapy notes is exactly the same as is defined in HIPAA. And they basically exclude the notes that has to do with, specifically on those notes. And I have to look at the specific definition as it applied in the HIPAA rules to be able to tell you the difference between your progress notes and the psychotherapy notes. And I'm happy to send you the 42 CFR section as well that would explain it. I think I have it somewhere.
Okay, great. We'll add that as a resource to include in our post-event email. So our next question asks, could you withhold disclosure of sexual orientation? I work with many LGBTQ patients who are not yet out to others in their lives.
So are these adolescent patients that have the parents or guardians have access to them? The patients can make a request not to provide that information, for example, or if you feel that there's going to be significant risk to the patient in terms of bodily or physical harm, then you should definitely restrict those records from disclosure. It just has to be on a case-by-case basis, or sort of depending on who you're making that disclosure. And you can put that in your policies in terms of who can access this information. But in general, if you don't think that there's a significant risk in physical or emotional harm to the person, then you can't really stop the dissemination of the information.
Okay, thank you. So this is a question about the implementation date. Does this apply to information going forward or also to information prior to April?
It applies to all information that you have. Well, The compliance has to be starting on April 5th. So if you are blocking information today, it's not going to affect the compliance. The compliance has to be starting from April 5th. And OIG has specified that they're not going to be very strict in applying applying the rule, as long as it's honest mistakes and you're really trying your best to comply, but then you're making these mistakes because these rules are pretty complicated. But again, any compliance has to be from April 1st forward, and it applies to information you gathered before that date.
Okay, our next question asks if you'll explain a little more about the definition of de-identified data.
So this is exactly just like HIPAA. So the HIPAA rules for electronic protected health information, it requires you can disclose de-identified data, meaning that you can separate. So the protected health information requires an identity and a health record. So if you separate those from one another, you really have a de-identified data. Identification parameters include things like name, medical records, social security number, address, location, family relations. On pictures, for example, you have tattoos that are distinguishable tattoos that that would identify a person. So those are the identifying data, meaning taking all the identification parameters out of the health record, so the health record cannot be recognized or tied to another person at any point.
Okay, thank you. Does the information blocking rule apply equally to electronic and to paper medical records?
No, it's for electronic health records information.
Okay.
Privacy rules apply to, continue to apply to paper records.
Okay. In a psychiatric practice, a lot of information, case-by-case basis, can cause harm. LGBTQ identity, for example, domestic abuse, or many others. The law is limited in addressing information blocking in regard to the psychiatric field. So they just asked if you would share your opinion about, best practices and how they should approach the implementation.
So in terms of using the exception of harm, there's a very specific definition and the scope of what significant harm is. So it has to be significant physical harm to a patient, or if your record includes the name of another person, and you feel like that other person can have a reputational or emotional or psychological or physical harm significantly to them. And then there's one more that requires, I can't remember the third one, but it's if you look at table 3, if you address table 3 of the rule, if I could pull it up here, I could take a look at it. It'll kind of enumerate the certain circumstances, and you're correct. They're really there's not a lot of information on psychotherapy notes or psychological effects, but they're pretty clear that unless you feel there's significant harm or the patient has requested you for not making certain aspects of their information or disclose certain aspect of their information to people, then you're under obligation to provide that information. And if other rules and laws don't apply, like, so for example, substance abuse part 2, it requires patient consent. Some state laws, for example, require that genetic testing and HIV testing be protected. So you can rely still on the applicable rules and regulations from each jurisdiction and the federal laws to protect the data. Minimum necessary, for example, is another limitation that you can apply in providing information to health payers, for example.
Does the definition of harm encompass self-harm that the patient may do to themselves if information is disclosed?
From what I've read, it does. It only in that context, it only applies when there is when it has to do with incarcerated, imprisoned persons. Otherwise, I do not believe it applies.
Okay. If psychotherapy notes are not part of EHI, where should they be stored instead?
Yeah, that's a good question. If you have if your electronic health records have allow you to segment the information, then you should separately store the psychotherapy notes from other progress notes that you disclose. If you cannot do that, and your records don't allow you to do that, then production of information has to be done for the scope of information that you can provide.
Okay, thank you. Is it considered information blocking to supply only the most recent, say, 3 years of a medical record to another physician when transferring patient care, when it is to prevent the fees the patient would incur for requesting the entire medical record?
I think you will probably have to provide the scope of medical records that has been requested from you. So if they ask you for the entire medical record, then you can provide it. You could ask the patient whether how extensive the patient would like to make this production. If it's infeasible for you, or if it's too costly, then you really have to document it in terms of um, you know, how you're providing it. But it seems like with the new technology, there should be readily access to the scope of the request. So the content and the manner exception allows you to sort of say, okay, the content that I'm providing is X content, and the manner it's going to be too costly for me to paper copy, photocopy this. Is going to be very difficult. Then you can rely on infeasibility exception from that and say that it's going to be very difficult for us. It's too copious for us to print all of this information out. But if the patient is willing to pay it, you're going to have to do it.
Okay, and then I have a clarifying question here. If the medical information is not entered in an AHR, then this is an exception. I could take the 30 days as established in Maryland to release the recodes.
So there's no workaround. So that would be one example of information blocking, by not entering your information into the electronic health records, if I'm understanding that correctly. The difference between the HIPAA rules and the information blocking rules is that the HIPAA rules provide you permission for certain under circumstances to provide information or disclose patient information. The information blocking rules require you to provide that information when HIPAA allows you to do that, or state rules allow you to do that. So by not entering your information electronic health record into the electronic health record in a timely manner, when you have access to electronic health record, then you're really impeding the process of transfer of information. I hope I got that. I think I'm not sure if that was.
Okay, if you have a follow-up question, feel free to type it into the chat or unmute yourself. I see we have a question about the slides, so I'm going to go ahead and drop the link for the slides to this webinar in again. And then one more question, Dr. Ghafourian. As people are preparing their administrative staff to document why they may have a denial and why that's in compliance with an exception that's defined as compliant for information blocking, do you have any recommendations about what information should absolutely be included as part of that documentation?
Can you read that again? Is it documented? Can you read that one more time so I can understand what the document?
Sure. So as administrative staff are documenting why they may have a denial for the information blocking, what items should be included in that documentation?
Yeah, so each one of these exceptions, they have key conditions, and you gotta have to make sure you document and meet those key conditions. And those are kind of I sort of put them in as you can see in each one of the slides. You have a list of conditions that you have to abide by. And there are other conditions that are not included here and is in the act. So documentation has to kind of reach those conditions of, let me go back to, for example, in privacy, for the precondition not satisfied, the rule specifically lays out what are the conditions for that specific precondition. And it says it has to be, your response has to be tailored, it has to apply consistently and non-discriminatory, it has to be in written policies or considered on a case-by-case basis. And then you have to show that you've taken reasonable efforts to fix the problem. So you have to document the entirety of those conditions. I mean, we can, we just don't have a lot of time to go through each one of these exceptions in this presentation. I mean, we can talk about just this one condition for half an hour, 45 minutes.
Okay, thank you, Dr. Gaforian. So I want to end on time today. I just want to thank everyone for joining us this afternoon. We will make this webinar available online via our YouTube channel. So please don't forget to subscribe to our channel for this educational content, but also other webinars, including telemedicine, remote patient monitoring, and E&M coding updates. A couple of things before we hop off today that we do want to let you know about. The first is that MedChi does continue to coordinate all clinician calls with Dr. Howard Haft of the Maryland Department of Health on COVID-19 every Wednesday at 5 p.m. So if you'd like to participate in an upcoming call, please visit us at montgomerymedicine.org to register. And then also MCMS has a COVID-19 vaccine toolkit to help your staff get ready to roll out the vaccine in your practice. So please visit us on the web to access those resources. And then I just want to say thank you once again to Dr. Gaforian for a wonderful presentation today.
Well, thank you.